They just
No,
transfer.
no, I am not concerned about his grievance. He may have a grievance with his transfer. There is a different forum to look into it. The court is not concerned. The court is concerned as to why you are withholding information, nothing else. The transfer issue is not over here.
Not afraid for access of public documents.
Right.
My lord, they on last occasion, pursuant to a lordship's order, my lord, they have provided me with the information. I have taken an exception to it.
Copy.
Nothing else applied to me.
Copy it.
How can I go?
Short.
Yes.
The fact remains, my lord, according to it.
Did you also file an opposition?
No. Kindly see the prayer in the repeated.
I'll come up. My lord, I'll come.
Kindly see the prayer in the repeated.
It is his case. Let him place.
Page 44.
Let him place. It is his case.
Kindly see the prayer.
Yes, yes. It is his case. I'll see the prayer. It is his petition. He will place it, and I'll see it definitely.
But just kindly come to your lordship's order,
Yes.
19th of June 2025.
Yes.
But the lordship order dated 19th June, my lord, paragraph number 12.
Yes.
Well, it says, my lord, the transfer policy of the industrial development officers under Directorate of MSME, the number of employees transferred from the establishment headquartered to other establishment more than 200 kilometers away from the permanent residential address of the officers in the last 1 decade be placed before this court on the returnable date. This was your lordship's relevant order. And my lord, on 2nd of July, your lordship has directed that the it has been paragraph 2, it has been specifically submitted there is no transfer policy in place in the subject department. The department merely follows certain guidelines. These are the two essential parts, my lord. First of all, the document which has been supplied, my lord, it is not a guideline. It's in the nature of compliance report before this court. Lord, your lordship may come to page number 5. Compliance report as per the order passed by Honorable Justice such and such dated 19/6/2025. But in my exception only, page number 5.
No, but then their compliance must be here.
It was handed over to me.
Oh, it was
This was
there.
given to me by your lordship. And the last occasion I have handed.
You handed over to the
Yes.
court.
It is extra checking the just may I permit to my
Well, it was just handed over to me. It was not taken on record of the
নিশ্চয়ই নেই রেকর্ডে
first. Kindly excuse me, Lord, may I permit to hand over?
1800 is this the
No,
document?
it is the document, my lord, but the answer they have given.
This one.
This is not on record.
It was not taken on record.
It was not
As
taken
per your lordship's order, it was just handed over to me.
right.
No,
Had,
no,
it
It was not
taken-
taken on record.
had it been taken on record, then it would have been reflected over
It
here.
was not taken on record.
Right.
Information has been produced before the court today, has been handed over to the London
Right.
advocate for the petitioner for perusal. It was not taken on record.
Yes, please.
But kindly see page number 5 of my exception.
Yes.
Compliance report as per order passed by Honorable Justice Amrita Sinha dated 19/6/2025 of WPA number 13305 of 2025, Sudip Chandra and another versus State of West Bengal and others. Well, this is given as a compliance report. My lord, they say that they follow a guideline. So guideline, my lord, it was not produced before this court. The second part is page 6. Your lordship, my lord, the order specifies how many percent was transferred from the headquarter more
To
than
some
200
other place more than 200
200
kilometers away.
Serial number 2, Shivdas Ganguly. My lord, he was transferred 200 kilometers in his residence. My lord, kindly see his Ondal development block, just the opposite, Poschim Bardhaman. And the next page, my lord, I have annexed Shivdas Ganguly. His address is at, my lord, page 8, address 07 Ghoshpara, Ondal, Durgapur. He was given posting at his home. It may be 200 kilometers, it's just the opposite. That is the information that has been supplied.
All right.
Now, my lord, I will just place the supplementary affidavit. That though by document your lordship have taken it on record. Supplementary. The information which has been supplied by them, and thereafter, my lord, an appeal have been preferred. Your lordship has directed in the pendency of the writ petition, appeal may be preferred. But this is the supplementary affidavit of the information that has been supplied.
Everything is supplied at the time of hearing.
Please just place my case. এটা তো আপনার কাছে আছে ডকুমেন্টটা। My lord,
Yes.
so far as query number 5, my lord, which is very important, my lord, I will just place 2-3 judgments in this regard. That my the reply which has been given, my lord, in query
Please
number,
provide copy of the note sheets.
yes,
Yes.
my lord, the next is very important. If required, the directorate shall provide the same before any court of law according to the direction of the honorable court. My lord, I respectfully submit, my lord, efficacious alternative remedy or a statutory appeal is not a bar of High Court to pass order for getting public information.
Hmm.
My lord, there are ample number of judge, and when can secrecy be maintained?
Hmm.
My lord, there is also a specific order judgments passed by the Honorable Supreme Court.
Hmm.
When it is a case of fundamental right, affecting fundamental right, my lord, I can pray before your lordship that the information may be supplied. As of now, my lord, the latest judgment of the Supreme Court, that is at paragraph 17, the citation the ditch. 2023 SCC online SC 1334.
SCC online.
Judgment
134. 134. 134.
1334. আরে জাজমেন্টের কপিটা দাও। 2023 এর কপিটা। May I just read it out, my lord? I shall দেখো বার করো। My lord, just may I read it out, paragraph 17. The right to information is not a statutory right, for it has been recognized as a constitutional right. Freedom of speech and expression under Article 19(1)(a) includes the right to acquire and disseminate information. Right to information has also been recognized as a facet Article 21. The intersection with the constitutional right entails and highlighted the burden of responsibility on the CICs and SICs to ensure that the individual get access to information on matters of public concern under the provisions of RTI Act. So, my lord, it is recognized as a fundamental right. আরে জাজমেন্টটা কোথায় এখনো বার করতে পারলে না?
Yes.
Well, next I would just place paragraph 14, efficacious alter. এটা আছে, এটা বার করো। 1998 volume 8 SCC 1.
Hmm. Place the point.
Well, just this I have with me, lord. Paragraph 14.
Yes.
Paragraph.
এটা রাজস্থান কি? এটা রাজস্থান। দেখো।
না, Whirlpool Corporation versus Registered Trademarks, Mumbai. Well, paragraph 14. Well, may I just read it out? Power to issue prerogative writs under Article 226 of the Constitution is plenary in nature and is not limited to any other provisions of the Constitution. This power can be exercised by the High Court not only for issuing writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari for enforcement of any fundamental rights contained in Part 3 of the Constitution, but also for any other purpose. And my lord, in paragraph 15, my lord, it says, my lord, under Article 226 of the Constitution, High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain writ petition. The High Court has imposed upon itself certain restriction, one of which is that if an effective and efficacious remedy is available, the High Court would normally exercise, not normally exercise its jurisdiction, but alternative remedy has been consistently held by this court not to operate as a bar in a not to operate a bar in at least 3 contingencies, namely where there is writ petition has been filed for enforcement of any fundamental rights, well, right to know and right to access public documents, and that which relates to my transfer has been made from the note sheets which they have prepared, and my lord, I have been sent from Kolkata to Alipurduar. My basic fundamental part.
You are a resident of which place?
Uh,
Kolkata.
No, I am a resident of North 24 Parganas.
Means
Not
close to Kolkata. at
close to
least.
Kolkata, close to
Right.
Kolkata, and I have been sent to Alipurduar. So there is a proposal, and my basic allegation in the before the challenging the order of transfer is that, my lord, the private respondent hearing, he is also made a party in those matters, my lord. There is a division bench stay order that because of his influence, because I was making, my lord, consistent representation that he should not be kept in the transfer assisting committee because he is a influential person of a ruling political dispensation. And my lord, he has proposed it, my transfer, and because of his influence, I have been transferred from Kolkata to Alipurduar. And my lord, the information which has been given, disclosed by my learned senior friend, it only shows I am the only person in the last 20 years who have been transferred more than 700 kilometers. So that is why, my lord, I need this information. The purpose behind it is entire note sheets and everything, my lord, so that I get some document to place it before the tribunal. It is fixed on next week. These documents maximum would be used for the purpose of giving it to the court to show the malafide of the transfer. This is my respectful submission. And my lord, so far as secrecy is concerned, I have one judgment, that is, my lord, when can secrecy be maintained? My lord, it is Dinesh Trivedi, 1997, volume 4, SCC 306.
1997.
1997, volume 4, SCC 306. Paragraph 16 and 17, my lord.
Proposition.
Secrecy. Maintaining secrecy.
Yes.
In the modern constitutional democratic, it is axiomatic that the citizens have a right to know about the affairs of the government which have been elected by them, seeks to formulate sound policies of governments aimed at their welfare. However, like all other rights, even this right has recognized limitation. It is by no means absolute. This court has in many an opportunity to accept itself upon this issue. In case of state of UP versus Rajnara and Matthew, eloquently expressed this proposition in the following words. My lord, in a government of responsibility like ours, where all the agents of public must be responsible for their conduct, there can be but few secrets. The people of this country have a right to know every public act, everything that is done in a public way by their public functionaries. They are entitled to know the particulars of every public transaction in all bearing. The right to know, which is derived from the concept of freedom of speech, though not absolute, is a factor which should make one wary when secrecy is claimed for transaction which can, at any rate, have no repercussion on public security. To cover with the veil of secrecy, the common routine business is not in the interest of public. Such secrecy can seldom be legitimately desired. It is generally desired for the purpose of the parties and policies or personal self-interest or bureaucratic routine. The responsibility of the officials to explain and to justify their acts is safeguarded against oppression and corruption. Paragraph 17 is very important. Implicit in this assertion, the proposition that transactions which have serious repercussions on public security, secrecy can legitimately be claimed because it would then be in the public interest. That such matters are not publicly disclosed or disseminated. But this is the main fundamental purpose of secrecy. If it have any repercussion in public security. Now, my lord, I have sought for a document. It directly affects me relating to my transfer order. From July 30th, 2024, the file was processed. I have just want that. But what is the bar? Even then, my lord, I would say there is an admission on the part of the person signing it is the Directorate of MSME SPIO. Query number 5. If required, this directorate shall provide the same before any court of law according to the direction of the Honorable Court. So they are willing to supply. Just what they are doing is they are dragging the time. Because right to information, my lord, it is also a time-bound manner. If the information is given, my lord, after 6 months or 1 year, my lord, it will be of no use. That is why, my lord, I have approached before your lordship.
Yes.
But so far as the affidavit filed today, just I've been copy. I'll look into it. But kindly see for a moment what is the prayer made in the writ petition at page 44. Sorry. Page 44. Prayer B. A writ in the nature of prohibiting the respondent not to implement the transfer order number such as dated 7th May 2025.
No, that is the annex chairman.
No, this is page 40.
No, that is the annexure of the other matters.
Sorry.
The prayer
Sorry,
starts from page
sorry,
14.
Page 14. Sorry.
Page 14, the prayer before your lordship. That was prayer before other court.
B. There is a commanding authorities and charged to provide immediately forthwith to furnish information as spread for the petitioner through RTI application dated 19th May 2005, 23rd May within 48 hours. Then provide me furnish authenticated copy of all documents relating to the transfer of the petitioner, particularly the representation made by the head of the instrument recommending the petitioner for transfer of the note sheet relating to the transfer of the petitioner and all other transfer related to the document after giving opportunity to inspect all documents within 48 hours. Then, kindly see the report of the AG Bengal. They have conducted an inquiry.
Where is that report?
Yes, kindly see.
Yes.
6 posts are there in Alipurdwar, out of which all are vacant.
And you found the petitioner to be the most appropriate person
Not
to
as
be sent over there?
we have transferred 5%. 5%. Can you see this serial number 5, Sudeep Chanda, headquarter to Kalchedi, and then Sumit Ghosh from headquarter to Mirik, Darjeeling district. Sri Ramkrishna Datto.
No, from Mirik to Alipurdwar and from Kolkata to Alipurdwar makes a lot of
We
difference.
should have to maintain the administration. But if there is nobody there, if DM is asking for a officer, and on the basis of the report of the AG Bengal, we have decided to fill up the vacancy.
Yes,
Okay,
you
transfer.
fill up the vacancy.
Yes.
First of all, you do not have a transfer policy. So you must accommodate people according to the guidelines that you are following. Right? And you found the petitioner to be the person who has to be carried
That is
from.
up to the administration, not for the who will be transferred, who will not be transferred. according to
This
the
is where the malafide is brought in.
But the malafide is to be whom? Against a person concerned, not against a officer. Has he been implemented? Any person is a malafide? Officer concerned? Can see director? Nothing. Can you see the who is the respondents?
Yes.
Prayer is on the RTI, not on the transfer order. Kindly consider this.
That he will take into consideration, but then he wants the note sheets. Why are you not supplying that?
Note sheets cannot all the times subject to approval matter. There is a judgment of this. Note sheets is a document detained by the government and by the correspondence between the one officer to the another officer. But
Yes.
all these documents cannot be made available publicly made.
You are not making it available to the public. It is his document. It
But,
concerns
provide
his
his document.
rights. It is his document.
His document. But if he has been agreed by the decision of the information officer, he has got a remedy under the.
No, he level that remedy. That is different. That is different. The court wants to know why are you not giving him the note sheet that he requires.
2010, volume 5, 1 SSC, page 1 to 6, paragraph 5 and 7. In our with the High Court had failed in rejecting the declaration on the aforesaid ground. First, the order of termination was passed without assigning its so-called notice, applied and without initiative disposition by the authorities. It is well settled that the declaration can be held to be maintained even an alternative remedy is available on an agreed party when the court or tribunal lacks inherent jurisdiction for enforcement of fundamental rights, or if there had been a violation of the principles or necessity or there is an act of question. The aforesaid exception recognized this court who had taken note of this court in Collector of Customs versus such and such. That is reported in 1961 report 150. Great. The above exception the court entered the alternative remedy was available to the party. The same view is spread. Such being the position of law of the admitted fact, the case that before termination of the service of petition, no dispute proceeding was initiated. It is clear from the record that the order of termination was passed without initiating this.
What is the proposition that has been laid down in that judgment that
Yes,
you are
I have
referring?
the copy
What
of
is
the
the
judgment.
proposition?
Efficacious also.
And my lord judgment sitting singly in Hemchand Gupta versus Union of India.
What is the proposition?
Proposition, my lord, so far as if an employee of the government or for pension approach this honorable court after the judgment of L. Chandra Kumar, my lord held that admitted quorum non-judice. My lord held, kindly see the last paragraph.
You show me the judgment that you are relying upon for not
120.
supplying the information sought for by the petitioner,
But
the note sheets.
But whether the writ petition could be entertained by your lordship, so for not giving any information except paid for by him, When there is a statutory appeal provided, that
Judgment, my learned senior friend is showing, my lord, it specifically says, according to me, subject to correction by your lordship, that efficacious alternative remedy is not a bar. Let him place, I will show. Paragraph.
No, this is, I can remember. This is
your
the,
lordship sitting in court number 24 delivered this judgment.
yes, this is all right. But then, is this against, this is in favor of the petitioner?
No. What?
That judgment relates to service, and this I am paying
Yes.
for right to
Under the
information.
right to
What
information.
is the prayer? What is the prayer made in the petition? Kindly see, it's a prayer.
Prayer is, my lord, access of public documents. Two prayers.
Some public documents provided under the Right to Information Act. If he is agreed by an information that is not available, then go to the first appeal, or then but ultimately the writ court.
What is your reason for not supplying the document, you please say?
Already you have given the information. Whatever the information available, we have given, and but a bunch of papers, but what have been transferred, or how long we have given. I've got a copy. I can hand over to your lordship.
No, this I see. I do not know whether you submitted today or the last day. I see this is over here. Thing is,
Total
the
transfer order.
No, my lord, I want
the court is not
note
concerned.
it that contains processing and decision of posting of industrial development officer. This is the question in question number.
The petitioner intends to have the documents which triggered his transfer.
Great.
Query number 5.
Query number 5. Question number.
Query number 5. This type of information is exempt from the disclosure if it does not protect the integrity of the government as specified in section 8, 9.
Where is the integrity of the government over here?
But if this is not satisfied with him, he can
Listen,
go to the court.
you are the government. You are not anybody else.
Yes,
You are not a private individual.
representing him.
You are the
This is a
government.
democratic setup. Government means
Yes, you are representing all the employees of your setup.
yes.
Now, relying on certain information, certain representation, you form the opinion to transfer the petitioner.
Yes.
What are those?
But a transfer is not for only one person. 5 persons as a stopgap measure we have transferred.
Stopgap?
No, but because of the requisition made by the.
So it's not stopgap.
No, but kindly see that there is a report by the AG Bengal that there is a 6 post is lying vacant. So far, Alipurduar is concerned, we have already transferred 1 person to keep up the situation because of the Election Commission of India is asking for more people in the district.
Election is over.
No. Election Commission is asking for more people because of verification and of the electoral roll is going on. That's why.
Yes. So is it your case that after verification is over, the petitioner will be brought back? That is not your case.
He could be debated. Certain information could be given there.
May
I cannot follow. Deputation means something else.
At least some people must be there. At least some people must be there. Post is lying vacant because he has been transferred to a particular place of posting. Cannot be said by the writ court research even after the El Chattopadhyay judgment. No, he should not be transferred.
The court is not going into the transfer issue.
Kindly say who has applied for the Right to Information Act.
Now you will go to various other issues.
No. Kindly see who has asked for the Right to Information. Priyanka Chanda. Priyanka Chanda
is my wife.
His wife.
Yes.
Then Priyanka Chanda is a.
Both of them are writ petitioners, my lord. I am both husband and wife. Both of them are.
Priyanka Chanda also a agreed person, and her husband is also a agreed person.
Of course, both of them.
And note sheet, how she can go access to that Priyanka Chanda? If I do a mistake, my wife will be made responsible by the court.
No, it is a access of public.
This is not a matter of making mistake, right?
No, assuming for a moment my client has committed wrong, and my wife will be held guilty of charges. Priyanka Chanda applied for certain information.
You are representing the government. Try to understand. You do not have a wife. You are the government. So it is not your wife making a mistake.
We cannot go beyond the law.
Exactly. You cannot go beyond the law. Now you are relying upon certain information given to you by somebody else, and relying on that you transfer somebody. What are those documents relying on which the petitioner was transferred?
I have placed before Lordship that there is a report by the AG Bengal that there is a post lying vacant.
There are posts lying vacant throughout the state in various departments.
Alipurduar.
Is it your case there is no vacancy in and around Kolkata, in and around it is you send him to Alipurduar?
No, but at this, what can I say? His grievance is against the transfer.
No, I am not concerned about his grievance. He may have a grievance with his transfer. There is a different forum to look into it. The court is not concerned. The court is concerned as to why you are withholding information. Nothing else. The transfer issue is not over here.
Not only we have transferred 26%.